you all so much for joining us for the estate planning workshop. Joining us today is Rebecca Haynes, attorney at Jeffrey Burr. Today she's going to be talking about the basics and importance of estate planning and helping us understand how to create our own estate plan. So I'm going to hand it over to her to get us started.
We are safely able to distance. I'm going to take this off so that hopefully you all can hear me a little bit better. Well, so it's great to be here. Again, my name is Rebecca Haynes. I'm an attorney at the law offices of Jeffrey Burr, and I've been practicing in this estate planning area of law for about 7 years now. And estate planning at its core is really just creating documents that speak for you when you can no longer speak for yourself. So whether that is you are incapacitated or when you pass away. And, you know, estate planning sounds, I think, kind of big and intimidating. You know, it's for if you have, you know, gobs of money and, you know, property and everything. But really, estate planning can be very simple, but then it can be complex just depending on your unique situation and what your goals are. So for today, I am going to just talk about the basics of estate planning. So, which is probate, avoidance, and incapacity planning, and just some of the other documents that we usually create around an estate plan. But to start off, so really again, so the point of having an estate plan for incapacity planning and probate avoidance. So probate is the court supervised process of transferring assets from a person who's passed away to their beneficiaries. And many of you may know what a will is, right? They are instructions for where you want your assets to go when you pass away. A lot of people think that with a will, you can actually avoid probate, which unfortunately isn't the case, and I'll explain why in just a minute. But probate, because it's a court supervised process, is a very expensive and time-consuming ordeal that you have to go through, or that your family anyway would have to go through when you're gone. And it's not fun to go through anyway, but when you're also dealing with the grief over a loss of a loved one, it's something to be avoided. And that process, just depending on the value of assets involved, can, you know, range from, you know, 6 months to multiple years. And so very expensive, time consuming, something that you want to avoid. But why probate is necessary is because, so let's say me, for example, my bank account has my name on it, Rebecca Haynes. So I have, as a person, the legal authority to sign on behalf of that account, to transfer funds, to you know, close the account, to open up a new one. I am me, so I can sign on my own behalf. But when I'm gone or incapacitated, nobody has that legal authority unless a court gets involved to appoint someone to say, okay, you know, Wells Fargo, you can listen to this person, you know, and they can act on, you know, my behalf because I'm no longer there. So the court has to get involved to give someone that legal authority in order to be able to, you know, authorize transactions on my behalf. And so ultimately, the will is the instructions, or are the instructions that the court looks at. So in making those distributions, so it names your executor, or the person that's in charge of distributing everything, you know, and who your beneficiaries are and all of that. And so ultimately things will go the way that you lay them out. It just takes a little while to get there. It's also a completely public process. And so if somebody wanted to, you know, they could pull up, you know, that probate proceeding and see what kind of assets are involved, you know, names of family members or beneficiaries, all of that. And so, you know, again, generally it's something to be avoided. But there are other things. So, and again, depending on what kind of property you have also dictates what kind of planning you do. So there are other probate avoidance mechanisms, like naming a beneficiary on a bank account, or like life insurance or a retirement plan. You can do that. If you own an account with another person as a joint owner, when you do that, then the survivor of you automatically is able to access that account. And so there are different things that you can do to avoid probate. But again, having a will is always, good too. But anyway, so we're going to talk about other ways to avoid probate. But that is what a will does. And a will to be valid, so you can handwrite a will and sign it. It's a holographic will, which is valid in Nevada. Or if you have a typewritten will, then as long as you sign it in front of 2 witnesses, then it is also valid. And that disposes of any personal property and real property, anything that you have in your individual name is what a will governs. And so again, a will is the most common estate planning tool, but something that we can use in Nevada to avoid probate, but accomplish, getting assets where they're supposed to be, is to create what's called a trust. And a trust is a will substitute in that you put provisions in there for where you want everything to go when you're gone. But the difference is that you create it right now and you actually transfer assets into that trust right now versus waiting for a court to allow somebody else to do it when you're gone. And I am a pictures person, so we're gonna see if you can kind of see this whiteboard behind me. But she's going to zoom in, but I'll draw big too. So with a trust, so again, it's something that you create during your lifetime that, again, is a will substitute. So in this document, you display, or excuse me, you lay out where you want things to go when you're gone. But again, you retitle your assets in the name of this trust right now. So like that bank account example that I just had. So instead of being me individually, it would be in the name of my trust, where I am the trustee or the manager over everything that's in that trust. But the trust can hold title to real property. So my house can be in there, bank accounts can be in there. If you have a business, that can be in there. Almost anything can be in the name of the trust. And so when that happens, so I'm the trustee. So during my lifetime, I can do whatever I want with assets that are in the trust. I have the legal authority as the trustee to do whatever I want. I can close accounts, I can open accounts, I can transfer assets, I can do pretty much anything. But the difference is that when I am incapacitated or I pass away, the trust doesn't have a life expectancy. So it is still around. And in the document, I name a successor or a successor trustee who's able to basically automatically step in and has the legal authority to act on behalf of this trust. So the successor trustee doesn't need a court to be involved to appoint them or anything like that. And that successor trustee is the one that would be able to get access to a bank account, to be able to sign a deed on behalf of, or for real property, do all of that. And then that person is the one that distributes everything the way that you want it to. So to whoever your beneficiaries are. A great thing about a trust, so this kind of trust, tax-wise, everything flows back through to you. There's no kind of implication or anything or downside to creating this kind of entity. It's very, very flexible. You can put in whatever provisions you want, really. Like, so for example, in a will, if you name people who are minors as beneficiaries, the default is that they would get everything at age 18. And I don't know how you all were when you were 18. If I got any sum of money at 18, I probably would not have anything to show for it right now, except for maybe a few extra pairs of shoes. But with a trust, what you can do is kind of extend that distribution date. So if you have minor children that you want to be beneficiaries, maybe you put till age 21 or 25. So that again, it's there for their benefit, but maybe they don't get that outright distribution or that check as soon as they turn 18. And so with a trust, So you also create a will, but it's called a pour over will, which says that, all right, if I pass away and there's anything in my individual name that I forgot or wasn't able to put into my trust during my lifetime, this will says everything else will be poured over into the trust and then governed according to its terms. And depending on the value of those assets, actually up until October of this year, you would have to go through a probate proceeding to get those assets transferred into the trust. But Nevada recently passed a statute that said that if you have a trust established during your lifetime and a pour over will, regardless of the value of assets that maybe didn't make it into the trust when you pass away, that through basically one hearing or very, very shortened time period, the court would allow you to transfer those assets into the trust, which is really, really good because sometimes actually transferring title is the hardest part with a trust, because you have to actually go to the bank to retitle assets, do things like that. But that means that, well, before what we had to do was like if there were assets that were over 300,000 in value going into the trust, we had to do a full probate proceeding, which again can take years to get done, which yeah, it's just something to be avoided. So, and two, with a trust, I think a lot of people associate, trust with, big, money families like the Kennedys and Carnegies, where it's really for people with lots and lots of funds, but really a trust, if you have, minors that are beneficiaries, if you own any real property, it's a very simple way to avoid probate and make sure that the transition when you're gone just is very, very easy for your family or those that you leave behind. And so again, the basics or the main kind of component of an estate plan, so is a trust or a will. And again, depending on what your situation is, one might work better than the other. This is the main part, but something that we also create are what are called healthcare and financial powers of attorney. And so the healthcare power of attorney just authorizes someone to talk to a doctor on your behalf if you're ever unable to. It also outlines end of life decisions so that if you were on life support, you can direct whether you would want that to be removed if there was no way for you to wake up from that. Or say, keep me on life support, no matter what, so you can lay out your wishes. And two, those kinds of decisions you don't really want to leave for your family members to decide for you. A lot of times those are the decisions that make it really, really hard for families. If some people, or if they don't know what your wishes were, and then people have different opinions about what to do in that situation, having it all laid out just makes it much more simple. And two, I think estate planning kind of has the connotation for doing it when you're old or like retirement or anything. But actually it's something I think that, people need to think about really as soon as they turn 18, because after you turn 18, like you're an adult, and really like if you went away to college, if you got into an accident, like if you were in the hospital, like your parents, they can get involved, but really they actually have no more legal authority to act on your behalf. So getting powers of attorney, just there for just in case, and hopefully you never have to use them, but it just makes things, a little bit easier if something were to happen. So that's the healthcare power of attorney. And then the financial power of attorney is if you were ever incapacitated, it gives your agent the ability to talk to like a utility company, a phone company, things like that on your behalf if you're ever unable to. So for assets that you have that aren't really worth anything, I guess is the way to put it. So, your phone company or, dealing with, Apple or things like that. So if you're ever incapacitated. So we kind of do all of those things as part of a comprehensive estate plan, again, just to make sure that no matter what situation arises, that again, you have documents in place that will allow people to act on your behalf if needed. And then also ultimately, dispose of your estate the way that you want to. And another thing too that a will does, or that we put in a will, is a guardianship nomination. So what that means is that if you are ever in a spot where you really have no capacity and need someone else to step into your shoes to be able to act for you legally, you appoint a guardian. And so you can choose who you want that to be in your will. If you don't have that appointment made in a document or in a valid last will and testament, then the state of Nevada could choose somebody for you. Or your family could, argue about who that person should be in court, which again, something to be avoided. And so that's for you personally, but also a guardianship nomination for minor children. So that if something were to happen again to you and you had minor kids, who you would want to take care of them or be responsible for them, if you were unable to. Because unfortunately, we see situations where, that nomination isn't made, and then different parts of the family or opposite sides of the family, kind of fight for a long time about who the person is that gets to watch over that minor child, which, eats up what you left behind for that child, and just, causes lots of just stress and drama that can be avoided. And so, again, just having these documents in place just makes things a lot easier. And estate planning too isn't just a one-time thing. It's meant to kind of grow and be flexible, like as life changes. So, maybe a will right now will cover everything that you have. But once you have kids, or maybe once you buy a piece of real property, it might make sense to have a trust. And two, again, these documents are amendable, are revocable. So again, as life changes, you can change them. And, depending on what's going on at the time or who you want maybe to be your executor or trustee, you can change your mind about that at any time. And again, it's meant to be very, very flexible, and can be whatever you want. And so again, this is just a very, very basic estate plan. There are other kinds of trusts and planning things that you can do for, again, depending on what your goals are. So if it's asset protection, there are different kinds of trusts that can accomplish that. If you are wanting to establish, a trust for, multiple generations, like for children, or to hold a business or anything, there's a lot that you can do, and lots of options. And Nevada is a great state for asset protection. So like the trust that I was just describing, the family trust. So even though title to assets is being held in the trust name and not you individually, it doesn't provide any additional asset protection, meaning that if you get into like a car accident, somebody brings a suit against you, you have a judgment against you, this kind of trust doesn't provide any additional protection. That creditor is still able to step into your shoes and get access basically to any assets that aren't already statutorily protected. And some things are protected, like a certain amount of wages, life insurance. There are insurance policies are also protected. I think I might have said that already. Retirement plans, and farm equipment. If you have farm equipment, that's also protected, just, so you know. But again, anything kind of above that, a creditor could reach that. But Nevada has what's called an asset protection trust, where you can set up a trust that works similarly to the way that the family trust does, and that it does accomplish probate avoidance and incapacity planning too. But it does have that extra feature of asset protection, where you still have access as a beneficiary. But after a 2-year seasoning period, all of the assets that are in there are protected from creditors, and that's future and unknown creditors. And they have that period of 2 years as that seasoning period to make sure that, again, it's for people that you don't know about that may come up in the future, again, like that random car accident. They're not vehicles to be used for, if you have that judgment against you, you get, notification of that judgment on Wednesday, create this trust on Thursday, fund it on Friday, and then on Monday say, oh, I don't have any more assets to pay this claim. They don't work in that situation. But again, just for those future unknowns, just because we are in such a litigious society, you know, a bad car accident or anything like that, you know, can be really, really devastating. And so there are some additional formalities with that kind of trust to get that kind of protection. But Nevada is one of 18 states that allows you to do that and does have the best laws or statutes surrounding those. And those trusts have been upheld by our Supreme Court, which other states just, it hasn't gone that far. So we have a really, really good track record. So asset protection, yep, is just another, again, objective or a goal that you can accomplish with estate planning. And so, yeah, the only other, I think, you know, comment I would make, so again, because these documents, again, they speak for you when you cannot speak for yourself. You know, you will see, and I'm sure you've seen, you know, there are online services or like do-it-yourself documents that, you know, you can fill out, you know, that are a will or a trust. And sometimes like the simple ones, like they do work. But a lot of times those are the documents that we see and they've kind of gone wrong. And that's just because, you know, there are contradictory provisions in there. You know, sometimes they aren't state specific, and so there are different rules about different things, and so they may not actually work the way that you want them to. You know, with the trust, if you don't title things correctly, then that could cause some issues later too. And so the doing it yourself just can be kind of risky. Again, just because it's not attorneys generally that are creating or advising you regarding these documents. And so, you know, I see some unfortunate situations where, you know, that has happened and you end up in court anyway because, you know, nobody can kind of figure out what was supposed to happen or what that person meant, you know, so it kind of just defeats the purpose. So, you know, hiring or engaging or at least talking with, you know, a professional about estate planning is a good idea, or even just getting an idea about, again, with your unique situation, what your goals are, kind of what would best fit your, you know, situation too. So that's really, I guess, kind of estate planning in a nutshell, kind of the super, you know, 10,000-foot version. But it also, well, a reason that you want to do estate planning is you don't want to end up like, let's see, some like you see it in the news every once in a while, like celebrities with these giant estates who have done no estate planning. So like Prince, I think, was the recent one, had no estate planning. So, I mean, his estate is going to be, well, just in courts for really, really long time. There's lots of fighting. It's really, really expensive. And I mean, not a lot of people have Prince's estate, but still, you know, you wouldn't want anything, I mean, that you wanted to have go to your family or children or anything, you know, be eaten up in, you know, court and attorney's fees, you know, when you're gone. So, yeah, just something to get some look into or be aware of. And, you know, a lot of times it's not really fun talking about or thinking about, you know, if you're ever incapacitated or, you know, when you pass away. I like to think about it though, as just kind of leaving a roadmap for the people that you have, you know, left behind, and just making it easier for them. Because again, they're already dealing with, you know, losing you. And then so just leaving something for them so that, you know, taking care of everything is really simple and streamlined. Even though it's a hard conversation to have and hard to think about, ultimately, you know, can again just make things simpler and easier. There you go. Does anybody have any questions about anything like that, or about estate planning in general, or any specific estate planning questions? Questions?
So one of the questions we got is, can you explain what an executor versus a guardian is?
Yeah, that's a great question. So the question was, what is the difference between an executor and a guardian? So different names for sometimes the same job, but depending on what document you're using, we have a different name for it. So on the trust side, you have the trustee. That's the person that's responsible for managing everything and making sure everything gets where you want it to go. An executor has that same job, but it's called an executor because you name that person in your will. So the executor is the manager over your estate in a will and has the same job as the trustee. Again, they're the ones that are overlooking the ultimate disposition of where you want everything to go. And hi. And so
That's Tuesday talk, right? Oh, I'm sorry, I'm messing up.
And so a guardian is someone that you name in your will, but the guardian only steps in if you are incapacitated. Your executor only steps in when you pass away, and that's when the will comes into effect about what to do with your property. But a guardian is for the time period where you're incapacitated, so you're not able to handle your own financial decisions, healthcare decisions, things like that. And so I guess the main difference is a guardian acts and manages everything for you during your lifetime while you're incapacitated. And then your executor is the one that steps in and manages everything when you've passed away. And so really it's the same manager, but just they step into play at different times.
Rules have to be beneficiary, or is that like completely different?
Nope, it is completely different. So a beneficiary, those are the people or persons that you name to ultimately receive something from your estate. And they can be completely different than who you name as the person in charge. So the trustee or the executor can be, can be a family member, it can be a trusted friend, it can be a professional. You really can name whoever you like, and it definitely does not have to be a beneficiary. And you can name one person to serve, you can name two people to serve together. When you get to more than two, it gets a little bit administratively complex because you have to have, 3 signatures to make anything happen. And even though with electronic signatures and everything, you can get them, but be like, trying to get 3 people on the phone to make one decision regarding payment of a utility bill, like that. So, 1 or 2 people, and again, you can name them right now, but then you can always, change and remove and replace those people later.
And if let's beneficiary, one of them be a guardian or executor?
Yep. So you don't have to have them be different people. You can have a beneficiary also serve as trustee or executor. And you can have 2 beneficiaries be the trustee or executor. Yeah, you can name, whoever. But yeah, I mean, it's through a will or through a trust, again, that person is just responsible for making sure everything gets to where it's supposed to go. And a lot of times, you name, or a person will name the same person to serve as guardian, executor, trustee, or power of attorney, because you have one person that you want to be responsible for, all financial decisions, like who's kind of involved with, all of that, so that they kind of know what to do, if you're incapacitated or if you pass away. Or you can name different people to serve in those capacities, but a lot of times I see the same person named. Easier, and it doesn't have to be a person in the state of Nevada either. It can be someone who lives anywhere. In the US is usually a little bit easier. There's some limitations for people who do live in or who are not US residents or citizens, but otherwise you can name anybody.
If we're ready to estate plan or get started, how can we find the best, organization or entity to help us with that?
Yeah, so most law firms or estate planning law firms in town, so in Vegas, Summerlin, and Henderson, they do offer complimentary consultations. So you can go in, meet with an attorney for, 30 minutes or so and just kind of talk about what options are there and just get a little bit more education. And, it's not something where you have to decide anything, right away. But just looking for, I'm a little bit biased. I work at a firm that all we do is estate planning, but because it is such an intricate area, going to a firm that does have its sole or primary practice area as estate planning, just because there are a lot of different nuances to it. And so, Googling an estate planning attorney, there are lots of really, really good ones here. And so, again, just you can call and have that consultation over the phone, again, because estate planning, it's really easy to talk about in generalities, but because every family situation is very, very unique, and depending on what assets involved, what your family situation is, whether you have minor children, if you're caring for a parent or, all sorts of things, again, it's a very, very tailored set of documents. So I'd recommend, contacting an attorney to talk about that, just to get an idea of,
Else has any questions, please feel free to unmute yourself or you can type it in the chat.
Oh, so I do see someone said, very long indeed. Their family has been in probate for 6 years. So, ouch. Yeah. And that's not uncommon, especially just again, depending on what assets are involved and everything. So, and like right now we're filing for hearing dates and like filing right now, the first available time that the court has is, next February. So, while it may not be like an overly complex process, it just takes a really, really long time because we have to wait for the court to be available. And it's just expensive. So there again.
Another question we had is, what are some of the most common mistakes you've seen people make when they're trying to put like a will together?
So mistakes for a will is sometimes, they are not executed correctly. So, had a situation recently where there was an older woman who, wasn't able to write really well. And so her daughter-in-law wrote out the will of where she wanted everything to go and then had, her mother-in-law sign it. But it didn't meet the statutory requirements of a valid last will and testament because it wasn't in the testator or the person creating the will's handwriting and it wasn't witnessed by 2 witnesses. And so if it's not legally or, statutorily executed, then it doesn't work. And then 2, like with trusts, things don't get titled correctly or there are contradictory, provisions in the document, or sometimes it's just unclear about where you want certain, assets to go or who the beneficiaries are, or again, just not titling things correctly. Or, just, I guess, not doing it at all. But, some people are okay with that. They say, all right, well, I'm not going to be here, so they can deal with it. Which is totally up to you too. But I think it's more just like on the legal Zoom and stuff like that, where, you fill out information regarding a trust, but it just isn't tailored to what you want, or for like, if you have minor beneficiaries or if you have someone as a beneficiary who receives government benefits, you could unknowingly disqualify them from those benefits by not structuring your gift to them a certain way. So, there's that risk too.
I have a question in the chat. Do you have any advice on how to make good decisions about seeking legal assistance? The costs for lawyers range from $1,000 to $3,000 for similar services. Sorry, it's a silly question, just not sure what to look for in a good estate planning lawyer.
No, that is a great question. And you're right, you're gonna find a range of prices for similar services. So honestly, looking for, or I mean, you can interview or meet with multiple attorneys because it really is and can be a lifelong relationship, right? So if you create your documents now, 5 years, your life looks a little different. You need to go back and amend your documents. So someone that you meet with and basically you have good, vibes with, for lack of a better word, or just someone that, you can trust. And I mean, Google reviews and different things like that, again, you can hear about other client experiences. I'd reiterate again, someone who, or a firm that primarily does estate planning versus, if you go to a firm's practice areas and they list like 30 different areas of law, again, I would be just a little bit cautious there. But I mean, yeah, just looking that up and calling a couple of different ones and seeing, who you feel the most comfortable with, I think, is the best way to do that. And two, I mean, yeah, fee wise, again, there's a range across the board and depending on what you want to do and all of that. So just really, yeah, who you feel comfortable with.
The next question is, do you have any recommendations on books or web pages to serve as resources?
So, web pages. So our firm's website actually, which is just jeffreyburr.com. So there are frequently asked questions about basic estate planning, trust, wills, and it kind of goes through and has a lot of the information that we've kind of gone over today. And so our website has a lot just of information, blogs about different, questions that we'll have about estate planning. Book wise, really think of any books off the top of my head, but I think, I mean, our website again does have a lot of information. So, and two, for the people that are on this call, I'm happy to answer questions. I don't know if my email is available as a host or anything, but I can provide that. So, I mean, basic questions and things, like I'm happy to be a resource.
Question is, often update our will or revisit what we have in the will?
Say about every 3 to 5 years, or when you have a major life event. So like if there's a marriage in the family, death in the family, or new additions to your family, or if you have, if you go from not owning real property to owning real property, every like 3 to 5 years, and then you can make sure that the people that you have listed, like as your agents or powers of attorney or executor or trustee, are still people that are in your life and who you would trust with that kind of responsibility. So every so often, because again, it isn't just, a one-time thing. It's the plan is supposed to kind of ebb and be flexible with life, I guess, which changes often.
Have any questions, Rebecca? You can type it in or you can unmute yourself.
How do VA benefits or like Social Security benefits from someone who's deceased, does that address through trusts or wills?
So it depends on what kind of benefit it is. So there are like there's social security, like you said, there are pension plans, like there are retirement plans like 401ks, IRAs, depending on what kind of asset it is. So there may be a death benefit or there may not. Like for pension plans, sometimes which people have through the VA, that is only available for a surviving spouse sometimes. But again, depending on how each plan is structured, there may or may not be a death benefit. Social Security wise, typically, again, that is only available for the surviving spouse or minors. There is like a $250, benefit sometimes that Social Security has for people other than a surviving spouse when someone passes away. But it totally depends on what kind of plan it is. But how that's handled through a will or a trust is actually through a beneficiary designation. So if there is a death benefit, then through the plan administrator or like through the VA, then what you can do, or like with a 401k or IRA, is that you just update your beneficiary designation. And so you can name individuals, you could name a primary beneficiary, contingent beneficiary. You could name a trust as a beneficiary. Those plans and things like that are very unique. They have to be held by a natural person or a human with a life expectancy, because that is how required minimum distributions are calculated and when you start taking those distributions. So they have to be in a person's individual name, but those are governed by beneficiary designation. And those can be updated, at any time.
Thank you. One more question. When someone bequeaths, like if you get money from a will or a trust, how does that, as the beneficiary, impact does you have to pay taxes on that?
Great question. So generally, no. If it is like proceeds from the sale of a house, like, or a cash account or investment account or anything, there's no income tax that you have to pay, because anything that you do receive as a gift is income tax free. The only time that does not apply is if you are receiving funds or you're named as a beneficiary of an IRA or 401k, where that is pre-tax money, where when you get it or when you pull it out, just like the owner would have to, you pay taxes at that point. But otherwise, anything that you receive as a beneficiary is income tax free. And there's no additional estate tax or death tax unless the total value of that decedent's estate for 2021 anyway is over $11,700,000. So at that point, there is an estate tax that is 40% over everything above that amount. Again, it's $11,700,000 this year, but it's kind of a moving number. It'll probably go down to about $6 million in January of next year. And so it kind of changes along, but that doesn't really affect most of our clients, but that is the only other tax. For Nevada, and that's a federal tax. Nevada doesn't have its own separate estate tax. Some states do.
Thank you so much.
Welcome. I'm happy to help. So yeah, I mean, if anybody does have any questions, I'm happy to be a resource. So
Else has any questions right now? We'll go ahead and wrap it up. But before we do, just want to give a huge thank you to you, Rebecca, for sharing your expertise with us today on this really important topic. And thank you to all our participants for joining us. I hope everyone has a great rest of your evening. Thank you so much.
all right, thank you.